Okay, should we want to get started? All right, so thank you and good evening and welcome. My name is Miriam Baer, and I'm the Vice Dean of Brooklyn Law School, and it is an absolute honor to kick off this event as we convene our second annual Sustainability and Future Cities Boot Camp. Tonight's event is emblematic of Brooklyn Law School's approach to the study of law and legal problems. In our classrooms, our scholarship, our advocacy, our interactions with policymakers, we strive to marry theory with practice. In college and grad school and law school, we all study philosophy, psychology, democratic theory, and we learn all of these disciplines to better understand why certain things happen. But we also know when we're studying these things that we should never take our eyes off of developments on the ground. And we never stop asking how we can best influence and learn from those developments on the ground. As a law school, we have been committed to furthering the study of law and the training of first-rate lawyers. But we also understand that law is the product of public policy. So whether we're talking about statutes or regulations or judicial cases or even just norms, law is the product of individual interactions at both a singular and aggregate level. And everything we do is keyed towards perfecting and better understanding those interactions. Now, this school enjoys a long and impressive history of training lawyers to enter public service at all levels of government, as you will hear from our keynote speaker. But at the same time that we've launched careers in public service, we've also evolved. And in the last few years in particular, a dedicated group of alumni and professors, and I'm talking about Professor Sobelsohn and Professor Rudikoff and Professor Askin, who's sitting back there, they have all been working on a program so that we could start introducing the law to new audiences. Next year, under their stewardship, we will launch 2 master's programs. One will be focused on fintech, and the other, which is a nice opportunity tonight, will be focused on sustainable cities. And these programs will be aimed at non-JDs, folks who are interested in studying questions of sustainability from a perspective that melds legal knowledge and policy-informed analysis. And these programs, although they are new, represent much of the work we've been doing all along with many of the people in this room. Now, it's no accident that this night's boot camp and our future master's program are focused on improving and studying local communities. Although we are a national law school whose faculty members are authorities in a wide array of legal fields, we all realize that so much of what we do impacts our local community. And as members of that community, we understand the importance of making it our focus when we bring together experts, government officials, and scholars. And indeed, that is why it is such a pleasure to be asked to introduce our keynote speaker today, Camille Joseph Varlack. She is the Chief of Staff to the 110th Mayor of the City of New York, Eric Adams, and even better from my perspective, she's a 2003 graduate of Brooklyn Law School, and we get to claim her as one of our own. She served as a senior editor for Brooklyn Journal of International Law. I believe you were on the moot court too, is that right? Oh my goodness. And she has a Bachelor of Arts in English from the State University of New York at Buffalo. And she has served in so many different levels of government. She started out as an ADA in the Brooklyn DA's office. And in fact, I was hearing you on one of the sound clouds when I was listening it today, and it totally resonated with me, the idea of having so many cases and having to figure out how does one actually triage them. I can imagine that those skills served you well. She has been a past chair of the New York State Joint Commission on Public Ethics. She also currently serves as a trustee of the State University of New York. And perhaps most importantly to all of us, she played a major role during COVID-19. She was on the New York State COVID-19 Task Force, and she is the former Deputy Director of State Operations, Chief Risk Officer, and Special Counsel for New York State, where she was responsible for managing the day-to-day operations of over 60 agencies and authorities. Now, on top of all that, she is the founding partner of her own law firm, Bradford, Edwards, and Varlack, where she was also the chief operating officer and was responsible for her firm's day-to-day operational leadership. And it was there that she maintained a litigation practice and focus on, of course, government investigations, employment defense, corporate governance, and, of course, crisis and risk management. So in other words, through all sorts, through both in a private setting and public settings, she has embodied exactly what we are thinking about when we bring together an evening like this, someone who has seen it all, experienced it all, and brings both a tremendous amount of integrity, intellect, and practicality to the problems we see at all levels of government. Please join me in welcoming Ms. Varlack, who will now have the keynote speech. Thank you so much.
Can everyone hear me? Okay? Okay, great. So first of all, thank you so much. I have not been back to the law school for some time. I was actually here, I think, last week, and I had an opportunity to participate in an amazing student panel, and so I am grateful to have the opportunity to be back and speak to you a little bit about my experience in my current role and some of what the administration is doing. So I wanted to start by talking to you a little bit about what a typical day as the Chief of Staff to the Mayor is like, some of the policies that I am focused on, and end by talking about what this administration is doing during Earth Week. Imagine, if you will, a child who came here from a very different place. I immigrated from Trinidad and Tobago as a child. I ended up living in Rochester, New York, where I was often alone as my mother worked incredibly hard to take care of me and to provide for our home. And I was stuck watching a lot of TV, including Perry Mason, and I loved the drama and the excitement of the courtroom. And so from that moment on, I knew that I wanted to be an attorney. I never considered being anything else, which I don't know that I would advise young aspiring lawyers today. I think you should consider lots of things. And every step that I ever took was really directed towards that. When I came to Brooklyn Law School, I came here because I was very focused on being in the community that I knew I was going to live in. And it was a haven for me. I found an incredible cohort. I worked full-time and went to school at night, and found some of the best friends of my life that are here. We were just all together this past Friday, and we are regularly together. So I hope for some of you who are students, you are finding those connections. But for me, BLS was a really incredibly pivotal period of time in my life. So you heard a little bit about my background, and I've finally gotten to a point where I think if for whatever reason I lose my job, hopefully I'll be able to get gainfully employed someplace else. But I love it. I love government. I love service. I love making government work for others, and I think it is one of the highest and best uses that anyone can have, and it's a responsibility that I take very seriously. In my role as Chief of Staff, I love solving complex problems, and crisis management is truly where I feel most alive. I was speaking briefly outside and mentioning that we were just having a random meeting of colleagues at City Hall, I guess it was 2 days ago, and then we heard the sirens and then realized that a building had collapsed outside, just really around the corner from City Hall. And just to see everyone grab their bags, grab their jackets, and immediately run to the scene, that is the moment where I really feel as though I am doing what I am supposed to do. On the scene, figuring it out, making sure that everyone is okay, understanding what all the logistical challenges are, making sure that all the agencies are coordinated and they're focused on what needs to be done. And most importantly, letting folks know some of you don't have a role. Just stand back and let the experts do their thing. I've always had a passion for operations and ensuring that there is discipline, rigor, and structure in all that I do. And there are a few places where that is more needed, that in government, and certainly at City Hall. And so I want to give an example of a case study of one of the things that I am working on. So I mentioned earlier that I'm an immigrant. I was born in Trinidad and Tobago and had the fortune to come here and work through the immigration process, and it worked pretty smoothly for me. But in my time in the administration, I have been quarterbacking our asylum seeker crisis, which I'm sure that many of you may be familiar with. I had the opportunity to travel to El Paso with the mayor to see firsthand what is happening at the border, how the border towns are struggling, how our Customs and Border Patrol staff and officers are struggling to deal with an unprecedented humanitarian crisis. The numbers really lay it out. There have been in excess of 55,000 people that have come into New York City in the past year. We still receive over 200 people a day, which means we get about 1,400 folks a week. Of those individuals, about 33,000 are still in our care. We have opened 103 emergency shelters and 8 humanitarian rescue and respite centers. And while those numbers tell the scope of the problem, and this is just a drop in the bucket, we are not the only city that has been impacted. What I really focus on are the stories, right, of these individuals and what they have come through. And for me, it's very personal because I juxtapose it against my own circumstances coming to this country. These are individuals that have walked for hundreds, if not thousands of miles. These are individuals, sometimes children whose parents have died on the way, families whose children have died on the way. They go through the Darien Pass where they see people who have died that are there. They get robbed, they are assaulted. This is their lived experience. They come to this country and oftentimes they are put on buses and sent to New York because that's the only place that they will get a ticket to, right? That's the only place that they can go. And they really come to New York thinking that this is a place of opportunity. And what we do is what New Yorkers have done for over 400 years, right? We rise up, we take care of them, and that is what we have been doing. These individuals have been treated as political pawns. They arrive here with no food, no clothing, no basic needs. They absolutely need medical care. And again, New Yorkers have risen to the occasion. From the first day that we were faced with this crisis, we have been focused on not just meeting our legal obligation, but our moral obligation. We have provided health care. We have welcomed in excess of 13,000 children into New York City public schools. We have launched Promise New York City, which provides free childcare to families, and released a holistic blueprint that really lays out what we are doing, why we are doing it, and what we need to do going forward. However, we have been very clear that what we need to a national crisis is a national response from our federal government. Yesterday, we stood along with Mayor Adams as he called on the federal government to listen to the single most consistent request that I heard in El Paso and that we have heard from our asylum seekers, our New Yorkers, as we refer to them, whether they are in the traditional homeless shelter or they're in the humanitarian shelter. They want to work. Right? Many of these individuals are professionals. They are doctors, they are lawyers, they are teachers, and they come here and they want to work so that they can make their American dream a reality. And my work as an asylum seeker crisis is just one of those odd things that you may not think a chief of staff will do, but I typically get called in to work on all sorts of crises, and that is the place where I feel most alive. But I wanted to make sure that I grounded this conversation in the work that you are involved in and acknowledge that we are in the middle of Earth Week. The mayor believes, as I do, that we should not be making environmental policies just during Earth Week or on Earth Day, but every day, and in everything that we do, we should be thinking about how we can best protect our planet. He often says that we came from two mothers, the one who birthed us and the earth we live on, and we have an obligation to care for both. For too long in our city, we have seen firsthand the disparities of climate change. Depending on your zip code, you could experience extreme heat, life-threatening flooding, and exposure to respiratory illness, to name a few. In my capacity as Deputy Director of State Operations, I had the honor and privilege to respond often to storms. I remember being in communities where we recognized that there had been a tornado in a place where you would never have expected a tornado to happen. Extreme heat, extreme flooding, all sorts of things that are happening that are a direct result of climate change. Under our administration, we have sought out and who sought opportunities to engage with the real threat of climate change, but also to unpack the deeper story of who has been left out of the conversation and most impacted. And so, as with every area of New York City government, our focus is first and foremost equity. And we have put equity in the middle, in the center of our climate agenda. Overall, Mayor Adams has pushed forward a climate agenda that has led to real results across the city. We have launched the Leading the Charge campaign, which is a commitment to build every new school to be 100% electric and retrofitting 100 existing schools in low-income Black and Brown communities historically impacted by respiratory illness. We have invested $70 million in the Clean Heat for All program to decarbonize NYCHA campuses. We have broken ground on a $1.6 billion capital project for the Gowanus Canal, and we are creating a roadmap to citywide composting by 2024. And these are just some of the initiatives that we have launched. Finally, since buildings are our city's biggest emitters, we are working hand in hand with building owners to meet our goals under Local Law 97. And there's one thing that I want to be clear on, and the mayor has been saying this since day one. We don't want to fine building owners unless we have to. That is money that we believe should be invested into the building for energy efficiency and carbon reduction measures. The message is simple. We don't want your money, we want your carbon. I want to say again that it has been incredibly foundational to have started my career here at Brooklyn Law School. I was fortunate to be in the trial advocacy clinic under then District Attorney Charles Hines, who was a professor at the school. And it was right here where we are all sitting that I started my exciting chapter of life. I was encouraged, I was nurtured here to develop my interest in public interest law. And I fell in love with the idea of practicing law and found my passion for civic leadership. And that began to plant the seeds of who I am today. I hope all of you have had a chance to experience the same sense of belonging and growth that I felt in these four walls. And I want you to understand that. And I spoke to someone earlier who was mentioning that Mayor Adams, I think, had been here and that he was incredibly inspirational. Unlike many people in the administration, I didn't really know Mayor Adams before I joined the administration. But over the course of last year, I had an opportunity to see him operate and to listen to the questions and the issues that matter to him. And what motivated me to join the administration is the fact that he says what he means, and he is very focused on delivering on that. So whether in private or in public, his focus is constantly equity. His focus is constantly bettering the lives of New Yorkers. And I want you to know that as I think has often been touted, particularly coming out of March, which was Women's History Month, there was a very large focus on the number of women that he has in his administration. But it's more than just the women. It's really people who have lived full lives, and the fact that his expectation in governance is that we are going to bring that authentic experience to the problems that we are solving. We have individuals in the administration who were impacted by Hurricane Sandy. They remember, right? Some of them still have relatives that are still in circumstances where they have been impacted by climate change or other issues. And when we sit down to solve these comprehensive and complex problems, the expectation is you're going to bring those stories. You're going to talk about what it was like to interact with New York City government. You are going to talk about what you think we can be doing better. And our goal is always to strive to impact New Yorkers in a positive way every day. Thank you.
Thank you, Camille, for sharing with us and providing a great overview of what the mayor, his proposals are, and his energy in doing great things for the city of New York. We're well on our way, and with great leadership, I think we'll get there. I'm Richard Sobelsohn, a professor of practice and adjunct professor of law at Brooklyn Law School. Welcome to our second annual Sustainability and Future Cities Boot Camp. In 2 days, we celebrate Earth Day, and it couldn't be more fitting and proper that we have our second annual boot camp this week. On April 18, 2019, New York City passed the Climate Mobilization Act, what we call the CMA, which was an ambitious legislative package, probably one of the most ambitious ones in the country. These laws represent New York City's dedication to the Paris Agreement carbon reduction targets, which seeks to have the city carbon neutral by 2050. And I know for most of us, years ago, 2050 was, good luck, we'll be around them. 2050 is not that many years away from now. The cornerstone of the CMA is Local Law 97, which Camille sort of introduced already. It affects New York City commercial and residential buildings that are 25,000 square feet and greater. So to put things in perspective, how many buildings are we talking about? About 40,000 of them in New York City. Local Law 97 outlines 2 introductory compliance periods, with the first one being 2024 to 2029. So think about that. That means less than 9 months from now. So while some CMA specifics are still being worked out, there are updates to them which will be shared with you tonight. The law targets New York City buildings with the highest emission intensity levels. The second compliance period is from 2030 to 2034. It has a reduction goal of 40% for these covered buildings. It's a difficult but not an impossible target. And in addition to Local Law 97, the CMA also includes other laws that are important to the built environment. Local Laws 92 and 94 relate to green roofs and solar panels for certain new construction and renovation projects. Local Law 95 requires letter grades showing building energy performance, which a lot of you have already seen in the lobbies of buildings. Local Law 96 establishes clean energy financing tools for building owners, which we'll hear about tonight as well. And Local Law 98 requires the Department of Buildings to include wind energy generation in its toolbox of renewable energy technologies. So although the above is all very daunting to most property owners, commercial and residential alike, tonight we hope to answer some of the questions that you may have about the CMA and what property owners can and need to do to comply with the Act. So to begin with the session, after I introduce our esteemed panel, I'm going to pose some questions for them. But first, let me tell you who we have on our panel. Starting all the way on the left, Laura Popa serves as the Deputy Commissioner of Sustainability for the New York City Department of Buildings. In this role, Laura leads the newly created Bureau of Sustainability, which will spearhead all sustainability initiatives at the department. She works closely with the DOB's team of sustainability specialists to push forward department actions that will help New York City achieve its climate goals and continue to serve as a model for energy efficiency and emissions reductions. Laura has more than 22 years of public service. She was a legal and policy advisor at the New York City City Council and the New York City Taxi and Limousine Commission. During her public service, Laura oversaw the development of legislation and policy at the City Council and directed the Council's efforts to enact landmark legislation that supports citywide greenhouse gas emission limits, the institutionalization of long-term sustainability and resiliency, and the expansion of clean and renewable energy. She also served on numerous advisory boards and task forces related to sustainability, and was a member of the Mayor's Commission on Gender Equity. Previously, Laura taught at Fordham Law School for many years. She's currently a lecturer at Columbia University. She's a longtime resident of Brooklyn. She earned her BA from New York University and her JD from Fordham Law School. Next to her is YuhTyng Patka. She's a partner at the law firm of Duval and Stachenfeld, where she's chair of the New York City Real Estate Tax and Incentives Group, co-chair of the PACE Finance Group, and a member of the Real Estate Practice Group. Tyng represents New York City real estate owners and developers on all aspects relating to real estate taxes, such as challenging their property tax appraisal value, tax certiorari, applying for tax and zoning incentive programs, such as 421A, ICAP, IDA, and inclusionary housing, and not-for-profits in obtaining real estate tax exemptions. Additionally, Tyng is a leading expert on the Climate Mobilization Act, including Local Law 97, and also counsels clients on PACE financing and its interconnection with property taxes. And at the end over here is William McCracken. He's a partner in the commercial litigation, cooperative and condominium housing, real estate litigation, and mediation arbitration practice groups at Ganfer, Shore, Leeds, and Zauderer. His practice focuses on complex commercial and real estate litigation and general representation of co-ops, condos, and sponsors. Bill is the co-chair of the Climate Change Committee of the Real Property Section of the New York State Bar Association. He's a member of the Publications Committee of the New York Real Property Law Journal. He's a member of the Executive Committee of the Real Property Section of the New York State Bar Association and a member of the New York City Bar's Professional Responsibility Committee. Bill writes and speaks on a broad range of topics, including New York's climate change legislation, co-op and condo, corporate governance, and attorneys' ethics. But now the fun will begin because I get to ask the questions. And we're going to start with Laura. Camille recently, she summarized the CMA really well with the phrase, "We don't want your money, we want your carbon." Since the first deadline of all New York City property owners of 25,000 square feet or greater is January 1st, 2024, and with particular focus on Local Law 97. Laura, would you please update us on where we are in the rulemaking process, what rules we have already promulgated, what resources may be available to building owners, what are the pathways for affordable housing, and what has to be done generally on the ground at the agency level to implement these laws? And I know I've asked you a lot.
Okay. Hi, everyone. So I just want to start a little back before Local 97 first, if I could.
Please.
So New York City's carbon inventory shows that almost 70% of our emissions comes from buildings. And so in order to reduce our emissions, we have to tackle that aspect. And I was on a 3-hour international meeting call this morning, and none of the other cities, Oslo, Amsterdam, London, have the focus on buildings like we do here in the city. Most of them, transportation, for example, is where most of their emissions come from, but not in New York City. So in 2007, 2008, we decided we were going to start to tackle buildings. And so what we did was we passed a few pieces of legislation that were mostly informational. So one was benchmarking. And so benchmarking required big buildings, and at the time we were looking at buildings that were 50,000 square feet and more, to basically measure their energy and water usage. And then they were compared to similarly situated buildings, and you can see if I had like a good building or a bad building. And then I knew that if my building was performing poorly, that I could be doing things to make it perform better and save money. So that was one law that we passed. And then the next law in the same package related to energy audits. And that, again, focused on these very large buildings, over 50,000 square feet. So we required buildings to undergo an energy audit. They would look at the auditors would come in, technical professionals, and look at, how your building was operating, and then, let you know where you could basically achieve savings and how you could do better. And the idea was that if you knew that you could do better, you would, right? And then, your energy auditor would perhaps show you where you could save money. And at the time, we were looking to put a retrofit requirement in that bill. And a retrofit means doing actual work in your building based on what the energy audit said. But it was very early days in the sustainability world conversation, and we were not anywhere able to politically get that in. We did do one retrofit requirement, and it was lighting. So all of you probably know lighting is the lowest hanging fruit, the easiest payback. You know, it's practically pays it back itself after the next, few months. And believe it or not, when we passed that bill in 2008, the deadline for retrofitting your lighting still hasn't happened. It's 2025. But if there's a building out there who hasn't done their lighting, they're losing money. So that would be a bad thing. I say all of this because cut to 2019 and we have Local Law 97. Now that was the retrofit bill. In the interim, before 2019 happened, we reduced the application, or we increased the application of the benchmarking and bill to apply to buildings that were 25,000 square feet and more. So we captured a lot more buildings in the city. And Local Law 19 applies, as Richard said, to buildings that are 25,000 square feet and more. So all of these buildings have to reduce their emissions over several compliance period until they get to net zero in 2050. So, as also mentioned, the first compliance period is 24 to 29, and the report for that is due May 1st, 2025. So that is the big day. We will receive reports from 42,000 buildings, which is about 21,000 properties, borough, block, and lot, as we refer to it. And the law was intentionally drafted so the worst 20% of performing buildings, the worst 20% performing buildings would be caught up in that first compliance period. So all of the buildings have to report, but it's really 20% of them that are going to have to do the work. And so we are coming upon this period. Now, when the law was drafted, so I actually helped draft the law. So in my old job at the council before I came to DOB to implement it, a lot was left to the agency to do rulemaking on. And that is something that's common when you have very technical legislation, and this is very, very technical legislation. And so there was an advisory board that was convened for 3 years. The advisory board met to do a report of recommendations, and it included, dozens and dozens and dozens of experts and industry stakeholders on various issues on how to implement this law. And so the report was finished in January, and we're looking at the recommendations. And we've done one big rule so far. And the big rule is letting building owners know kind of what their emissions limits are and how to calculate their emissions limits. And that's really important because now every building owner knows this is what my limit is, and kind of I can go and figure out what my potential fine will be. So there's a website for that. So you can go and put in your address and you'll see this could be my fine. Now the law was intentionally drafted to have very, very huge fines. It's the difference between your emissions limit and your actual emissions times $268. And there are buildings that are potentially facing millions and millions of dollars in fines if they don't reduce their emissions. But as Camille had said, the city's not interested in getting their money through fines, right? We want building owners to pay for the retrofits in their buildings. And so we are now working on new rules related to fines. So those have not come out yet. I wish they were out. But we're still working on that. One of the items that has been talked about in determining fines is this idea of a good faith effort. Building owners, the law allows DOB to consider good faith efforts when they're figuring out fines. And so we're trying to figure out what a good faith effort means. And it's certainly going to mean that a building owner is taking significant action towards reducing their emissions. And we've talked about publicly the idea of a decarbonization plan, which would basically be a plan that a building owner works with technical experts on to figure out how they're going to get to their net zero by 2050 and meet their emissions targets for each compliance period. So that's a big rule that we're working on that'll be finished soon. Another thing that we're still considering is how we take RECs into account. RECs are renewable energy credits. And you buy a REC, the state has a REC market, and that somehow will count towards your emissions. Now, the law requires that RECs have to sync into Zone J. They have to be directly used in New York City, and those are not available yet. They won't be available till 2027. But there is a lot of talk around RECs. There are advocates who think that building owners shouldn't be able to use RECs because they want the work done at the building level, and then there are building owners who want to buy RECs. But we're working with NYSERDA, that's the New York State Energy Research Development Authority, to figure out what that RECs market would look like potentially, because no one really knows what it's going to look like or how much the price of RECs are going to be. And so that's a rule that we're potentially, working on. We're considering the study for it. Another rule is related to affordable housing. And so there are two different pathways for compliance in the law. There's the regular commercial residential building pathway, which is the 320 pathway, because it's Section 320 of the law. And then there's the 321 buildings, which are affordable housing. That's basically if your building has 35% or more rent-regulated units, you fall in there. Houses of worship fall in there, and there are some other affordable housing buildings that fall in there. And those buildings can choose to do a prescriptive pathway, which means there's a menu of 12 items, like temperature controls would be one. And, cleaning your steam traps would be another, basically. And so we are looking to define what those measures are, and those affordable housing buildings can do those measures, and then they comply with the law. They don't have to meet these strict emissions reductions. And why that is, of course, is because it's affordable housing, and it's difficult for those buildings to get the financing to pay for that. Now, the city is working to draw down federal funding in order to pay or to help support those buildings do more than just the prescriptive path. That's going to be really important because those buildings make up a significant amount of the city's carbon. And so we're trying to work on another way, but the law was drafted so they had an easier pathway. The third thing was the resources. So we have something called NYC Accelerator. NYC Accelerator is a free resource for all building owners to get technical assistance on how to comply with 97 and to find out some financing options. And so every time we talk to building owners or we go out and we talk about Local Law 97, we say, please call NYC Accelerator. And they've helped over 10,000 buildings at this point, or had dealing with over 10,000 separate buildings for starting them on a pathway towards compliance. And so that is the city's resource for building owners. And we are working on trying to attract different financial products to the city, and which I'm sure the panelists can talk about probably better than I can. And then the last is implementation. So implementation is very complicated. It is an incredibly it's a big law, and it applies, as Richard said, to 40,000 buildings. And so we have to have the staff at DOB to do that. So I've been trying to build out staff. We have to have the processes in place, the forms in place, all of the rules in place. I just talked about a few rules that we were working on. There are probably going to be, at least 8 more after that. And so all of that has to be timed. So when May 1st, 2025 comes, we're ready to accept 40,000, compliance reports, and then review those reports and have protocol in place for that, and then deal with what happens after the review, if the building owners comply or not. And so all of that requires a lot of time. So we're on schedule, but we're all working very hard to implement.
Thank you. The next question's for Ting and Bill. So now that we have a good idea of what the law is and what needs to be done to comply with the law, what have your clients, what have property owners been doing to start satisfying those requirements?
You want to go first, or you want me to?
You can go first because you represent more.
Okay. Well, first of all, thank you all for coming. Thanks for having me. It's a pleasure. And as a practitioner, I don't know if that came through clear to you, but what Laura just explained to you was really helpful, actually. And I'm actually literally taking notes so I can find out, because she gave a little bit of clues as to what they're doing with the rulemaking. So I appreciate that. And thank you all for coming, like I said. What my practice is, and Richard sort of mentioned it, my firm represents, I think what's pertinent here is a lot of co-ops and condo buildings in the city, which multifamily as opposed to commercial buildings, two very different types of properties. And within multifamily buildings, you have two broad classes of building types that are important. You have like affordable housing, which is a huge important class. And then you have co-ops and condos, which is where I focus my practice. So it's very different, and it's a very specialized, unique area of law, although in New York City, there are a lot of co-ops and condos. So when I speak about what my clients are doing, it's like a subset of a subset of a subset, but it's still a huge number of buildings. And it's also poses very interesting and unique challenges because co-ops and condos generally are owner-operated, right? So the people that are in the management and making decisions on a co-op board, they're people who just happen to live in the building. They're not property managers. They're not experts in how to run a property, how to manage a building, how to comply with the law, right? They're just people like you and me. I'm on my co-op board, and I happen to know stuff, but that's not required. You have artists and teachers and everybody else who serve on these boards. And so it's a unique challenge when you're a lawyer for these boards because they might not necessarily have much expertise on how to comply with something like Local Law 97. So they really rely on their professionals and their lawyers to sort of walk them through it and explain it to them. And they may not understand the sort of importance of, why you need to comply, like all the technicalities that Laura walked us through, like why is this important to me, like what do I need to know about it? So there's a huge education process for my clients as to understand what the law is and what they have to do and why they should do it. So a big part of my job for the last 3 or 4 years has been sort of just educating co-op boards, condo boards as to what Local Law 97 is, why it's important for them, why they need to comply. And it's not just the technical stuff, it's the social issues because one thing about co-ops and condos is even though it is complicated and tricky for them, they generally do have money or access to funds and they hire people like us to find it. But, if they look hard enough, if they're smart enough, they can get it. Whereas that's not true necessarily for all affordable housing, or it's at least coming from different pots. So back to your question, Richard, what my buildings are doing, it really depends. It really depends on the particular co-op boards. If you have people who are focused and who care about these issues, they can do a lot. The building that I live in has done a huge amount of work in compliance with Local Law 97, like totally reorganizing their systems, totally like inspecting and thinking through how the building works entirely and going systematically and making a lot of retrofit changes, and it's saved us a lot of money, and we're not going to have any trouble complying, and we're really happy with it, but it takes a huge amount of work and investment and time and expense upfront from your co-op board. And then there are other co-op boards that basically have an attitude of what's the fire we have to put out this week? And this week it's garage inspections, right? Because that was just passed. And last week it was their Local Law 11 facade project. And before that it was the gas inspection project that they have to do. And if you try and tell them, like, it's really important that you focus on Local Law 97 because we have these compliance periods and you're going to get a fine in 2030, they sort of cut you off immediately. That's 2030. That's 2030's problem. That's future board's problem. That's not my problem. So I have a lot of buildings who are in that position. But in fairness, like, it is something that in the last, I'd say in the last year, honestly, like, it's become general knowledge among my clients that this is an issue and this is something you have to think about. And it just depends on the building. Like, I have a lot of buildings that have done a lot and a lot of buildings who haven't really thought about it yet.
Hi, everyone. I'm Ting. I'm a partner at Adler and Stachenfeld, formerly known as Duval and Stachenfeld, and we're exclusively a real estate law firm. We're a single office located in Midtown Manhattan, and we call ourselves a pure play in real estate. So we represent all players in real estate, from owners to lenders to investors. Starting in 2019 is when the law first came out. I was the one responsible in my firm for digesting the law and then summarizing it, educating everybody internally about it, but like more importantly, blasting our clients and contacts about Local Law 97 to just bring awareness to it and to educate them on it. If we recall the timing of this, it came out in April 2019. And then about 6 to 8 weeks later, in June of 2019, a bomb was dropped on New York City real estate when the rent laws were significantly changed with rent stabilization. So, in June of 2019, when the Housing Stability Tenant Protection Act, HSTPA, was passed, that became like the talk of the town, and it's really sucked the oxygen out of the room, and the CMA was kind of put aside, while everybody was talking about how the state of rent stabilization in New York City had fundamentally changed, along with some other changes to rent laws. So that was June of 2019, and if you fast forward 9 months to March of 2020, we had the COVID lockdowns. So then owners were scrambling along with the rest of the world to make sense of what was happening and to try to survive. And so again, like Local Law 97, very low on the priority list. And only until recently, like Bill said, has Local Law 97 really, I've noticed, started entering mainstream discussions. So going back to 2019, despite of what I said, the more sophisticated, like Class A type of asset owners, like we're talking about the Empire State Building, World Trade Center, those type of players have been on top of Local Law 97 from the very beginning. And they've had teams internally figuring out what to do. And those types of owners, like they're ready. They were previously already ready for 2024. They told me that they're planning for 2030, 2035, and beyond. Well, that's great, but the Class A owners, they make up such a small slice of real estate owners. Then you have like the remaining, you have the Class B and the Class C owners. And those are the ones that we've been trying to reach for years. Like I said, there's been a lot of distractions in the interim. But I've personally been shouting from the rooftops for years about this because my background is representing developers on property tax incentives. So working with various government agencies, I'm very familiar with all the red tape involved and how much work is involved with ultimately getting your construction permit completing construction and getting DOB sign-offs. I know that all takes time, and it's been concerning to me that, like Bill mentioned, it's human nature. You hear a date that feels very far off into the future, so it's human nature to just push it off. So back in 2019, 2020, everyone hears, oh, January of 2024, like that's so far off. So only around starting like the beginning of last year did people start really paying attention. And early last year, I told people it's still, you still have time. But now we're 8 months away from compliance, and I am still encountering owners that are unfamiliar with Local Law 97, and it's concerning for sure. But over the course of the years, when I've been educating owners, I describe to them, because the question is always like, okay, thanks, Ting. Like, now we know what Local Law 97, we know of its consequences. Like, what do we do? What's the first step? And so I kind of map out a decision tree for them. Like, the first step is to figure out, well, like, do you need to do anything? Are you already, like, are you a covered building, first of all? Are you 25,000 square feet or larger? If you are you in compliance? If you are, then, like, you can go, like, you can pass and go directly to go collect your $200, right? Like, but if you're not, so you need to first engage a professional to figure out, like, what is my building's carbon emission? And then after that, assuming your professional determines that you need to do something, then you have to explore options. What are my options? How much is each option going to cost? And how am I going to pay for that? So this all takes time, and depending on the type of owner and sophistication level of the owner is what really determines what owners have been doing. In my experience, it's the mom and pops obviously are the ones who are mostly still kind of catching up, like the family, like the multi-generational family owners who have been running a building for the same way for the last 3 generations. They're still catching up and figuring out what to do. And other more sophisticated owners are crunching the numbers. Like Laura mentioned, and like the mayor's chief of staff mentioned earlier, the city, even though the city doesn't want your money, they want your carbon. Savvy New York City owners are still going to crunch the numbers to see whether or not they can pay to play, so to speak. So I am aware of owners who are crunching the numbers, figuring out, okay, this is how much it's going to cost me to comply versus this is how much my penalty is going to be. And then, and sometimes they're landing with, like, it's easier for us to just pay the $1 million fine because we figured that it's going to cost us $3 million to comply.
Thank you for that. So first for Ting and Bill, and then for Laura, for those property owners hoping for a last-minute easing of requirements, or now starting to panic with so little time remaining to comply, do you think that if they start with some good faith efforts that some affected property owners will be given a break? So again, I'm asking Ting and Bill, from your client's perspective, are they hoping, against hope that, what they're going to do might suffice with what the DOB requires? And then, and I guess, Laura, you left it open because what is good faith effort? What level do we get to with a good faith effort? If they're, hiring an expert, that's one thing. If they're starting to implement things, that's another thing. What percent do they have to do to be able to meet that? So I'm going to ask the two of you to start, and then we'll come to Laura.
Well, I tend to err on the side of caution, and during COVID, or post-COVID, so to speak, in 21 and in 22, I've had clients and owners approach me with, what do you think about the city, the chances of the city relaxing or postponing Local Law 97 compliance? And I'm realistic. I told them, I honestly do not believe that the city is going to be compelled. And owners are in disbelief. They're like, but what about COVID? I was like, I understand, I hear you. However, this law was passed in April 2019. The city purposely gave owners 5 years of runway to comply. So there's always going to be owners out there who try to push the envelope and they're trying to be optimistic. But I've told them repeatedly, consistently that, don't bank on the fact that the city is going to be backing down, especially since when the CMA was passed, it was passed with huge fanfare. Like New York City was a market leader in this. Other large cities like Boston, for example, followed suit after New York City passed Local Law 97. So all the more reason why I don't believe that New York City, now having become a leader in this, is going to back down.
Got it. Bill?
Yeah, well, that's one of the things that I was paying attention to when Laura was speaking. I was hoping she would spill the beans on what the city is going to put in their rule on good faith efforts, because we've Ting and I and other colleagues have been speculating for years as to what that really means under the law, and trying to guess, and because our clients ask us and we say, well, I don't really know, like what are good faith efforts. So that's one thing. We're all sort of waiting as practitioners to be told what that means, and then we'll tell our clients. And you always have clients and people who are sort of waiting for the Deus Ex Machina to come and save them from thinking about this. You have that Glen Oaks lawsuit where people are thinking maybe that the courts will like declare the law unconstitutional, and so they won't have to worry about it. But just stepping back for a minute, I mean, the problem that I have as a counselor and as a fiduciary to my buildings is that the hardest thing to get them to do is to think about it and start on it. When they start engaging with the process, I haven't had any experience with any building, any client, any property owner that starts doing the stuff and doesn't see the wisdom of it and the benefit of it just on its own terms, leaving aside compliance, leaving aside potential fines. Like, these are things that pay for themselves, become cheaper to run over the long term, make your property more resilient and sustainable, and like increase the sort of prestige of your building, basically, like particularly for commercial buildings, like you're talking, Ting was talking with their Class A buildings. These are things that tenants are now looking for, right? So it's really, yes, you need to figure out what good faith efforts are to comply, but really, in my mind, like once you start engaging in actual good faith efforts, whatever they are, you're going to be carried along in a process that makes sense for your building to continue to do, right? And at least that's the hope. If you get yourself in a situation where you actually make what you think are good faith efforts and you find that you can't afford it, or that they're not getting you to a point where you can avoid fines, I'm going to feel comfortable going to DOB and telling them and laying it all out. Like, this is what we did. We tried, and we need some sort of adjustment. And then you let the chips fall. But, I can't do that as an attorney, as an advocate, if they just sort of throw their hands up in 2023 and say, well, I don't know, I'm not going to do anything. So, we're encouraging, like, we're trying to get our clients to at least start the process and see how it goes.
So Laura, you've got a really tough job, because when you're drafting your rules and designing your programs, you're going to have to face the Bills of the world. And that's daunting in and of itself. So what's your, what's your thinking? What's the DOB's thinking?
So right now we're focused on, we'll have a very clear definition of good faith effort. It's not going to be like you won't understand what it is. It'll be super clear, and there'll be metrics attached. But we're right now just focused on what that means for the first compliance period, because I think it's going to be different. Part of Local 97 is creating this market, like for heat pumps, and Camille mentioned the Night to Clean Heat program, and they're literally buying like 35,000 units and creating like manufacturers of these window heat pump products. And so the way the landscape exists today will be different, in 1 year, 3 year, 4 years from now, when the 2030 compliance period hits, when the other buildings have to comply. So we're focused on the first compliance period and what it means to make a good faith effort. We haven't, I mean, not that I could say, but we haven't landed anywhere yet. It's complicated, as I think I've used that word several times now, around this law, but it will definitely mean action, significant action, on the part of building owners. And, what Bill said, I was, I'm in agreement in and very interested to hear, like, that once building owners start on the path, they'll finish the path, and we really want them to be engaged right now. And, the decarb plan it's a long game. 2050 is all the way out. There are, lower hanging fruit, still easier things building owners can do now, and later, as the different compliance periods happen, they'll have to do more, right? And so, we still have buildings burning oil. They're the ones who have to, do work, for example, for the first compliance period. And so, we're not going to tell a building owner what to do. Obviously the experts will do that. The advisors will do that. We just have to, measure, make sure they calculated right and measure if they did it or not. But we're still working on the definition is the bottom line. And the mayor's been very clear that he is implementing Local Law 97, fully implementing it. That's been said publicly many times. So there won't be a back down from that.
Okay, so that is actually a good segue to my next question. So if we think about the period starting in 2030, because we heard tonight already that it's pretty much, I think you told us, only 20% of the buildings probably will not be in compliance. But when we hit 2030 and we've got a 40% reduction requirement, so again, first with Ting and Bill, and then to you, Laura, are any of your clients, are any of these affected property owners being proactive, thinking about 2030? So Bill, if the ball is starting to roll in compliance for 2024, are they sort of figuring out, well, 2030 is 6 years away, and that's not, that far away, and if we're going to put any capital expenditures into it now, should we maybe do a little bit more to be able to at least satisfy that next period?
Yeah, I have a couple of things to say about this. Again, I'm speaking from the context of multifamily co-ops and condos, whereas Ting is dealing with a lot more commercial buildings, so it's different. I don't happen to have, just by happenstance, any buildings that I'm aware of that are facing fines beginning in 2025. Like they're already, to the extent that they're looking at it at all, they're looking at 2030 because that's when it really ratchets down. So it's a fairly small class of buildings that are getting hit in 2024, starting in 2024. And I don't personally represent any of them, so I haven't had that problem. Having said that, I may represent some of them because co-ops and condos are crazy and they don't call their lawyers, they don't call their advisors, they just float through the air, and they may be like about to get hit, right? And I can't do that for them. I'm not their manager. So it's very possible that I have buildings that are about to get hit in 2025 with fines, and I just don't know about it. I don't think it's likely because we do send out a lot of circulars. We try and educate our clients, obviously, but that's in the realm of possibility. But as far as I know, all of my buildings that are focusing on it, and we're treating it as very important right now today, they're all actually out at 2030. So.
Ting, what about on the commercial side?
Yeah, kind of echoing what Bill says, that a lot of my clients are looking far ahead into 2030 because similarly, I'm not aware of any buildings that are not in compliance. But again, being their lawyer, like there's not really much legal for me to do for commercial building owners, like the office towers and stuff. So I don't really know. Yeah, they if they are or are not in compliance with 2024. But from discussions I've had, they are viewing the long game because if they do need to put in, like a new boiler or replace windows or something, it just makes more sense to look ahead into the future. And a lot of the owners that I speak to, like they were already planning on these capital expenditures and upgrades. So it's just kind of coinciding with, it's a few birds with one stone where if we need to upgrade the building, then let's look to make sure that the upgrades we choose are compliant for as far out for Local Law 97 as feasible at the moment.
Just one more thing about it, because Ting reminded me. Any well-run building will have a capital improvement plan, right? And they will know the expected life of their building systems. And as part of the benchmarking reports and things like that, most buildings should have this, like their inventory of what their systems are. So they should already know like what's coming down the pike, what needs to be replaced. So it's not actually that hard to plan pretty far into the future as to what needs to be replaced and the timings of it and things like that. So yes, it's not surprising to me. It's appropriate to me that they're already out in 2020, 2030. I don't know why I can't say that, but even beyond.
So Laura, if I heard you correctly, thinking about compliance and thinking about the rules for 2030, you're still thinking about 24. So it's probably too early for the DOB to think about 2030.
So I will mention one thing. We're doing a rule on what we're calling it beneficial electrification, and we're going to give owners who are electrifying early credits towards their emissions reductions. And we're looking at the 2030.
I'm taking notes. This is great.
That's great. So we want to incentivize early electrification, and that will obviously be targeted towards the 2030 spot. I will say too, it's 80% of the buildings who'll have to do something in 2030, while only 20% have to do them for the first compliance period. And, there's going to be, we're waiting to see what the workforce issue is going to be and the supply issue. But I think we're mostly, it's an unknown about the workforce that's going to be available. And so, like the contractors and people who put in the heat pumps and upgrade the electricity, and so we obviously would love to avoid a situation where everyone's rushing in the last year to comply in for 2030. That would be hard, but we're relying on the fact that as Bill and Ting said, there are capital plans that buildings more sophisticated buildings have. And so, it'll be on that cycle and it won't necessarily be the rush to the end. That's what we're hoping. But we are thinking about 2030, just not going to deal with good faith efforts for 2030.
I had a comment about Laura bringing up electrification of buildings. So the feedback, and it's more so a critique of the city's push to electrify buildings. What I've heard from the real estate industry is that it sounds great on paper, but implementation is likely going to be more difficult because right now the city's infrastructure, from what I've been told, it would be a difficult task to handle all of these buildings coming onto the grid. And so, Laura, do you know, is the city also addressing that at the same time? Because there's a big push for electrification, like the financing, CPACE financing that the city's offering to help owners fund and finance energy efficient improvements. There is a push to make electrification as one of the eligibility requirements for financing.
So there's a great report that I can't quote the statistics, the Urban Green
The
report.
Urban Green Report, I was
Yeah.
going to say, yeah.
Yeah, which kind of gives and I encourage anyone to read it who's interested, but which kind of gives a timeline for how many buildings can come on before we start to have a problem with electrification. It's a fairly significant number. We're working with Con Ed. We have regular contact with Con Ed for many reasons. And one of them is there is a subset of buildings that were built in a certain time period that need to upgrade their electricity in order to even consider electrification, significantly upgrade their electricity. And one gentleman put it to me that if he turns on his microwave, the lights flicker. And so we're trying to put buildings in different categories of different characteristics and then deal with each building characteristic category. And so electrification is tricky for those buildings because so much work has to go into the building before they can electrify to upgrade. So that's one category. But we do think for at least the short term that we can take on a number of buildings to electrify.
I found that study really convincing. The Urban Green Council put out a study a year and a half ago on electrification of the grid. And if I had been giving this, speaking at this panel 3 years ago, I would have been talking about the concern about brownouts and things like that. And I'm not saying that anymore. And I'm not an engineer. I don't know. But I found this study pretty interesting and fairly convincing that the grid actually can support it with some work. The thing that I've always been terrified by is something you mentioned about the workforce, and I think back when I met Ting in 2019 was at an Urban Green Council program, and there was a chart in it where they were sort of like talking about this great new toy that we have, the Climate Mobilization Act, and they're like, all we need to do is increase our engineering capacity by like something like 8 times, over the next 9 years or something. It's like, what are you talking about? Like, that's crazy, right? And it really, part of my job is when clients ask me what we should do, and you say, you have your decision tree that Ting mentioned, but like you had to hire a consultant to do this. And like, who do you hire? Who's available? Who's a snake oil salesman, right? Like, it's very difficult to know. And they're flooding the market with these energy consultants, and there's some super smart people that are doing it and very helpful, but it's hard to know who's good and who's bad. And you need so much capacity on that side of it that, like, that's where a lot of buildings, like, that's one reason that I've been telling my buildings to get in early with people, because at least we can get them with reputable, established engineers and things that we can be comfortable that you're going to get good advice from them.
So we are running out of time, and I want to leave a little bit of time for questions and answers, but I guess in a short, succinct answer, which is always difficult for attorneys for us to do, how are our clients going to pay for all of this?
Good question. I'll let Ting answer that one first. This is Ting's expertise.
It depends on the type of asset owner, right? If you're a multifamily owner, the cost is borne on the owner, but they're going to increase rents. If you are an office building owner, you're going to find a way to insert language into your lease where you can pass the cost of compliance off onto the tenant. And I mentioned earlier, C-PACE financing is the city's answer to how to finance these retrofits, but this is left for discussion for another day. C-PACE doesn't always work for all owners, and the C-PACE program is still very much in its pilot phase in New York City. So this is the literal $1 million question: how are owners going to pay for the cost of Local Law 97?
Yeah, I really think it's actually the toughest nut to crack in all this, because we can find engineers and we do have the buildings. We know what we can do. None of the technology is that exotic. It's just really like not bankrupting our property owners and making it like sensible for them to actually pull the trigger and do it. The Inflation Reduction Act is a huge game changer in a lot of ways, but we still don't quite know how yet. It's a huge amount of money, and we know that it's going to make its way to property owners, but we can't, like, and I've been asking, like, attending a lot of webinars and talking to a lot of people, and it's like, it's unclear, how that's going to get to us. PACE financing is a great concept and obviously very much needed to finance these things, but we haven't found a vehicle for property owners to access that capital like in an efficient way yet. And so part of our job again is to like nail the stuff down and get it in front of our clients. But
Can I just add that there is money that Con Ed has and has paid for supported compliance with 97 and NYSERDA as well. So that money existed apart from the IRA funding, but we're obviously very much counting on significant IRA funding to help with this going forward.
what we really want is to be able to, now you can type your address in and find out what your emissions limits are and maybe what your fines are. What I really want to do is type in my address and say, like, you have these grants, these incentives, these loans available to you, done. Like that. That's what we need, but we can't have that yet.
Okay, thank you. So if we could just pass around the mic. We really only have time for a few questions, but if anybody has questions from the audience, somebody's going to bring a mic to you. Thank you.
Is it working? Okay.
Hi, this is a question for Laura, but it's coming off of something that Bill raised. A lot of my practice is with architects, engineers, and the construction trades with regards to the licenses and registrations and credentials issued by DOB. Is there going to be a sustainability inspector, or is there going to be some credential that's going to be issued that somebody is going to have in order to do the inspections that are going to, that all of this is going to depend upon?
So we're working out the implementation process, and what that means. The law requires an RDP a registered design professional.
Right.
I know you know, just in case others don't, to submit the compliance report and sign off on that. And obviously, depending on the work, certain professionals have to do that work. We haven't reached the point where we're figuring out what an audit would look like of the information. You know, we get our benchmarking information. I don't know that we're at the point where we've thought about this, about credentialing an inspector.
Okay, thank you.
Go as fast as I can.
Thank you. This is a fairly big picture question, mostly directed towards Laura, so it may be a tiny bit unfair. But given that the carbon neutral goal is 2050, that is quite a ways in the future, and we're talking about 2023, 2025, 2030 goals right now. Obviously, balancing the practical need for allowing business owners and developers time to implement carbon reduction solutions for their buildings. Can you speak to the decision-making process, to the timeline balancing around that, of why there's such an extended time period to try and reach these carbon neutrality goals, given the impending dangers of climate change? Like, how does that decision get made in terms of the timeline? Kind of big, sorry.
I'm trying to think back. The bill was in play for years. And obviously we had, the 1.5, trying to make sure we did the 40% by 2030. And, I guess, electrification is good if the grid is clean. And so we had to kind of give enough time for New York State to clean its grid. And we passed this law before the CLCPA was passed. We didn't know that was going to pass. And so part of it was just trying to game out really and guess when the grid would be clean, so the law would be meaningful. And so I would say that's why the timeline was out to, and of course at the time it was 80 by 50. If that was the goal. When we first did our first New York City carbon goal, the first law was 30 by 30, 30% reduction by 2030. And then all of a sudden, several years later, we're talking 80 by 50, and then it was net zero. And so, we were kind of following that, and giving building owners enough time to plan, and the useful life of equipment and all of that, and how long we thought it would take for fossil fuels. It wasn't scientific, but that was some of the thinking that went into it.
We have time for one more question.
This is for all panelists. I know it was mentioned earlier that fines weren't going to be issued for noncompliance with 97.
No.
Is that not the case?
No.
They are, yeah, they are.
Are actually, okay. Never mind. Pass it on.
I don't think I need anything here. Will the improved electrification raise the question of reopening power plants, such as the nuclear plant north of the city?
No, I don't believe so. New York State has pretty aggressive goals to bring renewables to the city. And none of it involves nuclear. It's all going to be renewables. and they're on their way to doing it. We have to see how it works out. But there is no indication that nuclear, which of course is zero carbon, is gonna open.
Okay, so we are out of time, but I'd like to thank our panelists for sharing their expertise with us tonight. This session is being recorded, so it'll be available on the school's YouTube channel in a few days. And those of you that are here for continuing legal education credit, please make sure you've signed in and you sign out. And otherwise, we have a networking event right now, which will go from 8 to 9. So thank you very much for joining us.
Thank you all.